Can the IRS levy or garnish my bank accounts? If the IRS has satisfied the pre-levy requirements according to federal statutes for a tax liability assessed against you, the IRS can levy any property belonging to you, including bank accounts. In United States v. National Bank of Commerce in 1985, the Supreme Court held that the statutory language, all property and rights to property, appearing in Section 6331, is broad and reveals on its face that Congress meant to reach every interest in property that a taxpayer might have. Indeed, the Court has long held the view that stronger language could hardly have been selected to reveal a purpose to assure the collection of taxes. Glass City Bank v. United States, 1945. In situations where a delinquent taxpayer's property is held by a third party, the IRS serves a notice of levy upon that third party pursuant to Section 6332A. This notice gives the IRS the right to all property levied upon and creates a custodial relationship between the person holding the property and the IRS so that the property comes into the constructive possession of the government. Section 6332A of the Code requires the person in possession of or obligated with respect to property levied upon to surrender it to the Secretary of the Treasury upon demand. Failure to do so results in personal liability under Section 6332D1, which provides any person who fails or refuses to surrender any property or rights to property subject to levy upon demand by the Secretary shall be liable in his own person and estate to the United States in a sum equal to the value of the property or rights not so surrendered, but not exceeding the amount of taxes for the collection of which such levy has been made, together with costs and interest on such sum at the underpayment rate established under Section 6621 from the date of such levy. It is well established that a bank account is a species of property subject to levy within the meaning of Sections 6331 and 6332. A levy against intangible property, such as a bank account, is made by service of a notice of levy. Service of a notice of levy confers upon the United States the right to all property levied, and the property comes into the constructive possession of the government upon filing of the notice of levy. A levy is effective upon service of the notice of levy. The Treasury regulations echo this point with respect to banks, stating, "A levy on deposits held by a bank applies to those funds on deposit at the time the levy is made, up to the amount of the levy, and is effective as of the time the levy is made." Subsection C of 26 U.S.C. Section 6332 provides a special rule with respect to banks. Any bank shall surrender, subject to an attachment or execution under judicial process, any deposits, including interest thereon, in such bank only after 21 days after service of levy, as explained by the House Conference Report for the 1988 Act, which added this subsection. This special rule permits the Secretary to demand surrender of bank accounts only after 21 days in escrow have passed since service of the notice of levy on the accounts. Thus, while service of the notice of IRS levy under the general rule creates a custodial relationship between the person holding the property and the United States until the property is turned over to the government, the special rule with respect to banks under Section 6332C extends that custodial escrow period to a minimum of 21 days. The Treasury regulations also emphasize the custodial escrow relationship during this period, explaining that no withdrawals may be made on levied upon deposits during the 21-day holding period or any extension thereof. This 21-day period allows the IRS and the taxpayer or another individual named on the account to resolve issues regarding ownership of the account while the money is held by the bank, a practical measure the IRS was already seeking to address by asking the bank to place such a hold on accounts with two names by the time Section 6332C was enacted in 1988. The language "any deposits, including interest thereon" in Section 6332C requires the bank to include any interest that is accrued on the deposits prior to and during the holding period, and any extension thereof, under the terms of the bank's agreement with its depositor, when it surrenders the levy deposits. Daniel W. Layton, the author of this post, is a former IRS trial attorney and former federal prosecutor who was tasked with handling criminal tax prosecutions and civil litigation, including tax refund suits, lien enforcement, and foreclosures. As a tax attorney in private practice in Newport Beach, he uses his knowledge of IRS procedures and rules to keep the IRS in check and protect his clients' rights. He may be contacted at 949-301-9829. Voice assistance provided by legal assistant Benjamin Tu.